Hi, welcome. I see we've got people joining us. We're going to wait just about a minute to make sure everybody gets signed on. In the meantime, I am Lisa from San Diego Law Library, and with me today is our speaker attorney, Stephanie Germani, who works with San Diego Volunteer Lawyer Program. And she will be sharing this information with you today about habitability, tenants' rights to a safe and habitable home. So we're so glad you're joining us today. I think it's a really hot topic from what I can tell here at the library and some of the reference questions we get. So I think it's very timely. A couple of housekeeping things that I wanted to mention for those of you joining us. I think most people are starting to get familiar with Zoom, but I never assume that everybody is. So I like to mention that this is an interactive program and there's a way for you to post questions today. What you need to do is use the Q&A function if you're one of our attendees. You'll see that there's a button that says chat, but that's not the one that is for questions. It's Q&A. And if you click on that, there's a place for you to type a question in. And you can choose to do that either with your name or anonymously, perfectly fine either way. One thing that we would ask you, though, is that this session today is not for individual legal advice. It's for general information. So please keep any questions general rather than about your very specific situation. And then hopefully Stephanie should be able to get to those closer to the end of the program after she's gotten through her material. The other thing I wanted to mention is you will see a link to an online survey with just a few questions at the end of the program. And we would appreciate if some of you would take a few minutes and take the survey for us and give us some feedback. We always like that for planning for future programs. So I think by now just about everybody who's going to be here is here. So I'm going to disappear myself and turn things over to Stephanie.
Thank you. Hello, everyone. Thank you for being here with me today. As Leslie said, I'm Stephanie Germani. I'm an attorney in San Diego County, and today I'll be discussing the habitability of residential rental properties in California. Please note, nothing I present here is legal advice. We are not forming an attorney-client relationship, and nothing you say here today will be considered confidential. Now, California is home to some of the most expensive and competitive housing markets in the United States. With high demand for rental properties, as a tenant, it is important to know your rights and what your landlord is required to provide in terms of livable conditions. And as a landlord, it is crucial to understand your responsibilities in maintaining a safe and healthy environment for your tenants. So the relationship between landlords and tenants gets a bad rap. Most see it as adversarial, pitting landlords and tenants against each other and blaming each other when problems arise. But it really is a partnership. Landlords provide housing and tenants provide a means of income to the landlords. In this relationship, each has responsibilities to the other. Tenants have the responsibilities spelled out in their lease agreement, like to pay rent, and landlords also have responsibilities spelled out in the lease agreement. And even if the lease does not say it, California landlords are bound by the implied warranty of habitability. This is the duty for all California landlords to provide their residential tenants with a rental unit that is fit to live in, or what we call habitable. So in California, habitable means that the rental unit is fit for occupation by human beings and that it substantially complies with state and local building and health codes that materially affect tenants' health and safety. California law makes landlords and tenants each responsible for certain kinds of repairs, although landlords ultimately are legally responsible for ensuring that their rental units are habitable. All residential leases in California contain an implied warranty of habitability. It applies to every residential lease and it cannot be waived or limited in the lease. Any attempt to do so is unenforceable. So before renting a property to a tenant, a landlord must make the rental property fit for humans to live in, or as we just learned, habitable, safe, sanitary, and fit for human occupancy. This includes basic necessities such as working plumbing, heating, and electrical systems, as well as a safe and sanitary environment. While the unit is being rented, the implied warranty of habitability dictates that landlords are legally responsible to repair problems that make the rental unit unfit to live in or uninhabitable. So the landlord must repair substantial defects in the rental unit and substantial failures to comply with state and local building and health codes. However, the landlord is not responsible under the implied warranty of habitability for repairing damages that were caused by the tenant or the tenant's family, guests, or pets. Tenants also have responsibilities when it comes to maintaining the habitability of their rental property. Tenants are required by law to take reasonable care of their rental units. For example, tenants are responsible for keeping their living space clean and disposing of garbage properly. Tenants are also responsible to repair all damage from their neglect or their guests or their pets, the damage they do. Tenants should also report any maintenance issues to their landlord in a timely manner. The sooner the better. I suggest immediately and always in writing. So the landlord's responsibilities. Generally, the landlord also must complete maintenance work, which is necessary to keep the rental unit livable. This means that landlords are responsible for providing tenants with a living space that is free from health hazards, that is structurally sound, and equipped with basic amenities such as heating, plumbing, and electricity. This means that all pipes, faucets, and toilets must be in good working condition, and electrical outlets must be installed and functioning safely. Furthermore, landlords must ensure that their rental properties are free from any health and safety hazards. Additionally, landlords must provide tenants with proper ventilation and lighting to ensure a safe living environment. If uninhabitable conditions exist, landlords must take steps to fix the issue. This does not mean that lesser inconvenience, such as a dripping faucet, breach the warranty of habitability. But let's talk about what does. So there are many conditions that can make a rental unit legally uninhabitable. California Civil Code, specifically section 1941.1, which you can read on the internet, outlines the requirements for habitable living conditions. This law states that landlords must provide tenants with effective waterproofing and weather protection of the roof and exterior walls, including unbroken windows and doors, plumbing and gas facilities in good working order, heating facilities in good working order, electrical, lighting, wiring, and equipment in good working order, clean and sanitary buildings, grounds, including elevators if those are in the building, adequate trash receptacles, floors, stairways, and railings in good repair. So we're talking about a roof that keeps the weather out, regular access to hot water, a working heater, sturdy floors and walls, absence of significant dangers from toxins, such as lead and asbestos, absence of vermin and insects such as rats and mice. The implied warranty of habitability is not violated merely because the rental unit is not in perfect, aesthetically pleasing condition. If you don't like the color of the walls, that's not what we're talking about. Nor is the implied warranty of habitability violated if there are minor housing code violations, which standing alone do not affect habitability. It is important to understand that the list I just ran through describes issues that are major and not minor. So a defect is considered minor, not because of the cost of the repair, but because it renders the property uninhabitable. So it might take $5 to fix the electrical system, but it could be a major issue that affects your health and safety living in that property. So that's major and minor, a big difference. When a California landlord refuses to provide these basic requirements or fails to make repairs when necessary, then the implied warranty of habitability has been breached. If you believe your landlord is providing you with an uninhabitable home, it is best to document those conditions with photographs, video, and written repair requests with descriptions and the date of the problem and how long that condition has been occurring. Now, let's discuss what tenants can do if their landlord is not meeting their habitability obligations. If a tenant believes that their rental property is uninhabitable and they properly notify their landlord of the issue, and the landlord does not address the issue, tenants have a few options. Tenants can withhold the rent until the issue is resolved. They can make the repair themselves and deduct the cost of the repair from the rent. They can move out and terminate their lease, or they can sue their landlord for damages. It is important to note that tenants cannot be evicted for taking action to enforce their habitability rights. Also, you're going to hear me say this a lot: proper notice to the landlord. This is the method required by law to inform the landlord of the needed repair. In most habitability cases, proper documentation of notice to the landlord is an issue. So I suggest put everything in writing and keep copies of everything. As we go through the tenant options, I'm going to use a real life example that happened to me to help illustrate the points of each option. So in my situation, I was living in a tiny 240 square foot casita in Claremont, and I was paying $1,000 a month in rent. I had the best landlord. He was a very nice guy. He took care of everything right away until my power went out. It wasn't a neighborhood outage. It didn't affect the other house on his property. It was just my tiny studio. So I notified him. I sent him an email. He came out right away like he always did. He fiddled with the electrical panel and the power was back on for about 20 minutes. And then boom, power went out again. So my landlord, he got an electrician out the very next day. The electrician said, oh, well, the panel is old. And the problem is the wires keep coming loose. So my landlord tells me, Stephanie, a new panel is $9,000. And I just don't have that in my budget right now. So if the power goes out again, he tells me to just walk the 40 feet from my little studio to the electricity box on the house and tighten the wire. I said, okay, I can tighten a wire. My landlord has been awesome so far. He got the electrician out the next day and it's just a little loose wire. I can tighten that. So the next day, after walking to this panel about 20 times, because that's how many times the power went out, I called my landlord and I said, no, you need to fix this. This is my electricity. I can't be fixing it 20 times a day. This is just not reasonable. So to his credit, he replaced the panel, but I know not all landlords would do that. So we're going to go through the options I just mentioned, and we're going to use my example to see how we would handle the situation I was in. Okay, so option number one, repair and deduct. The repair and deduct remedy allows a tenant to deduct money from the rent to pay for repairs of defects in the rental unit if the repairs would not cost more than 1 month's rent. This remedy covers substandard conditions that affect the tenant's health and safety and that substantially breach the implied warranty of habitability. Examples might include a leak in the roof, during the rainy season, no hot running water, or a gas leak. So as a practical matter, the repair and deduct remedy allows a tenant to make needed repairs of serious conditions without filing a lawsuit against your landlord. The basic requirements and steps for using the repair and deduct remedy are as follows. 1, the defects must be serious and directly related to the tenant's health and safety. The repairs cannot cost more than 1 month's rent. The tenant cannot use the repair and deduct remedy more than twice in any 12-month period. The tenant or the tenant's family, guests, or pets must not have caused the defects that require the repair. The tenant must inform the landlord, either orally or in writing, of the repairs that are needed. I suggest always use written request. And the tenant must give the landlord a reasonable period of time to make the repairs before undertaking the repairs themselves. What is a reasonable period of time? Glad you asked. Okay. This depends on the defect and the type of repairs that are needed. The law usually considers 30 days to be reasonable, but a shorter period may be considered reasonable depending on the situation. For example, if the furnace is broken and it's dead of winter, maybe not California winter, but maybe up north, California, you get some snow, Big Bear or something, then maybe just 1 or 2 days may be considered reasonable. If the landlord does not make the repairs within a reasonable period of time, the tenant may either make the repairs or hire someone to do them. The tenant may then deduct the cost of the repairs from the rent when it's due. So let's go back to my example. I have my $1,000 a month little apartment. My electricity is on the fritz. Could I have used the repair and deduct method? Probably not. Because if the only way to fix the problem was to replace the whole electrical panel, which costs $9,000, and I was paying $1,000 a month in rent, then the cost of the repair exceeded my monthly rent. And so this wouldn't be an option for me. Note, even if the repair is a viable option, tenants face the risk that the repair may not be serious enough to justify using the repair and deduct remedy. Remember, the defect has to be substantially affecting the habitability of the property. So this is a subjective standard. So you want to be sure, I'm going to give you some resources at the end, people you can consult with if you're not sure. Give me 1 second. Okay. Because if you use this method and you were not justified in using it or didn't give your landlord proper notice, the landlord can sue you to recover the rent you didn't pay or serve you a 3-day notice to pay or move out, which could lead to an unlawful detainer lawsuit to evict you. So we always want to be careful. All right. Option 2. Withholding the rent. By law, a tenant is allowed to withhold or stop paying some or all of the rent if the landlord does not fix serious defects that violate the implied warranty of habitability. Again, the defects must be substantial. They must be serious ones that threaten the tenant's health or safety. So an example, there was a court case, Green versus Superior Court. And this court case gave Californians the implied warranty of habitability. These are the defects it found serious enough to justify the tenant's withholding rent. The collapse and non-repair of the bathroom ceiling, the continued presence of rats, mice, and insects, lack of any heat in 4 of the apartment's rooms, plumbing blockages, exposed and faulty wiring, an illegally installed and dangerous stove. So in the green case, all of these defects were present. And there were also many violations of the local housing and building codes. In other situations, the defects that would justify rent withholding may be different, but the defects would still have to be serious ones that threaten the tenant's health and safety. Okay, so the basic requirements and steps for using the rent withholding remedy are: the defects or the repairs that are needed must threaten the tenant's health and safety. The tenant or the tenant's family, guests, or pets must not have caused the defects that require repair. The tenant must give the landlord proper notice of the repairs that are needed. The tenant must give the landlord a reasonable period of time to make the repairs. If the landlord does not make the repairs within a reasonable period of time, the tenant can withhold some or all of the rent, and the tenant can continue to withhold the rent until the repairs are made. So I know you're all wondering, if this is my situation, how much rent can I withhold as a tenant? So of course, the law does not provide a clear test for determining how much rent is reasonable for the tenant to withhold, but judges in rent withholding cases often use the following method. There are a few methods. I'm going to give you the most commonly used. It's called the percentage reduction in rent. So the percentage of the rental unit that is uninhabitable is determined, and the rent is reduced by that amount. For example, if one of the rental's 4 rooms is uninhabitable, the tenant could withhold 25% of the rent. The tenant would then have to pay the remaining 75% of the rent. So you have 4 rooms in your apartment, 1 isn't inhabitable, so a quarter of your space isn't usable. They're saying 25% would be reasonable to withhold. If you do withhold your rent money, suggest not spending it. Because as we talked about in the repair and deduct method, there's always a risk that you aren't justified to withhold the rent. And if that's the case, you may be required to pay the landlord some or all of the withheld rent. So remember, there's always risks involved. So in my example with my electricity, could I have used the rent withholding method? I think I could have. How much rent would have been reasonable for me to withhold? That's the harder question. What I would have done is I would have talked to my landlord and said, I'm willing to wait until you can replace the electricity panel and not report you to code enforcement for the violation of the implied warranty of habitability. But during that wait, we need to negotiate a rent reduction. And if we couldn't have come to an agreement, there are a few more options I could have exercised. One of those options is the abandonment remedy. So where a tenant can abandon or move out of a seriously defective rental unit is one option. A tenant might use this abandonment remedy when the defects would cost more than 1 month's rent to repair, but it's not a requirement of the remedy. The abandonment remedy has most of the same requirements and basic steps as the repair and deduct remedy. In order to use the abandonment remedy, the rental unit must have substandard conditions that affect the tenant's health and safety, and that substantially breach the implied warranty of habitability. If the tenant uses this remedy properly, the tenant is not responsible for paying further rent once they have abandoned the rental unit. The basic requirements and steps for lawfully abandoning a rental unit are: the defects must be serious and directly related to the tenant's health and safety. The tenant or the tenant's family, guests, or pets must not have caused the defects that require the repair. The tenants must give the landlord proper notice of the repairs that are needed. And the tenant must give the landlord a reasonable period of time to make the needed repairs. For example, if tree roots block the main sewer drain and none of the toilets or drains work, a reasonable period of time might be as little as 1 or 2 days. So if the landlord does not make the repairs within a reasonable period of time, the tenant should notify the landlord in writing of the tenant's reasons for moving and then actually move out. The tenant should return all of the rental unit keys to the landlord as well. Again, there are the same risks with this method that we've discussed previously. Now, if I had complied with notice requirements, do you think I could have abandoned my rental unit with the electricity issues? I think I could have. Electricity is one of the conditions required for a habitable home. But what makes the issue difficult is something I talked about at the beginning of the presentation: the California rental market. I was renting a tiny house with a washer and a dryer and a patio, and I had a nice closet. And it was $1,000 a month in Claremont. I didn't want to give up that place. So while I think I would have been reasonable if I abandoned the rental property because of the electricity issue substantially affecting the home's habitability, I wanted my landlord to fix the issue so I can continue to live there. So that's something, you know, if you might face, you have a great property, you have this issue, the rental market is tough right now. So, you know, sometimes you're between a rock and a hard place and you have to make a tough decision. Okay, so the last option I'm discussing today is one I hope you never have to do. It is filing a lawsuit. Okay, so a tenant can file a lawsuit against the landlord to recover monetary damages if the landlord does not repair serious defects in the rental unit in a timely manner. For damages less than $10,000, the tenant can file a lawsuit in small claims court in the county where the rental property is located. If the tenant wins the lawsuit, the court may award the tenant his or her actual damages plus special damages, an amount ranging from $100 to $5,000. Special damages are costs that the tenant incurs, such as the cost of a motel room, because the landlord did not repair defects in the rental unit. The party who wins the lawsuit is entitled to recover his or her costs of bringing the suit, for example, the cost you pay to file the lawsuit, plus reasonable attorney fees as awarded by the court pursuant to any statute or the contract of the parties. So what does your lease say about attorney fees? Now, while attorneys cannot appear in small claims court with you, a tenant may still have attorney fees. For example, you could hire one to draft your demand letter to your to your landlord, or to fill out the small claims complaint form. The court may also order a landlord to stop or eliminate the issue causing the habitability breach. For example, a court could order the landlord to repair a leaky roof and could, what we call, retain jurisdiction over the case until the roof is fixed, meaning they're not going to dismiss the case. So this type of relief is called injunctive relief, and it's something you usually can't get in small claims court, but we have a civil code, section 1942.4, that allows for it. I want to make special note that local code enforcement officials can also order the landlord to correct violations by way of a notice of violation in order to abate. In fact, that is a necessary step for this type of lawsuit. In order for a tenant to prevail in their lawsuit and recover both actual and special damages against their landlord, all of the following conditions must be met. Note, a tenant can still prevail on your claim without meeting these conditions, but you won't recover actual and special damages. So these are our lawsuit remedy steps. The rental unit has a serious habitability defect that endangers the health, life, safety, property, or welfare of the occupants of the unit or the public. A housing inspector has inspected the minimum requirements for habitability or has declared the unit substandard because, for example, a structural hazard, inadequate sanitation, and the landlord has been given by the housing inspector written notice of the landlord's obligation to repair the substandard conditions. The substandard conditions continue to exist for 35 days after the housing inspector mailed the notice to the landlord, and the landlord does not have a good cause for failing to make the repairs. I can't afford it is not a good cause. The nuisance or substandard conditions were not caused by the tenant or the tenant's family, guests, or pets, and the landlord collects or demands rent, issues a notice of rent increase, or issues a 3-day notice to pay rent or quit after all of the conditions I just mentioned have been met. So we'll go back to my electricity example with my little tiny house. Could I have sued my landlord? Well, there was a serious habitability issue. Neither I or my family or my pets caused it, but I failed to have a housing inspector or code enforcement inspect the problem. But let's say I did that and code enforcement had issued a notice to the landlord to make the repair, and he didn't make it for 35 days after the notice was sent by code enforcement. Then could I have sued him? Still not yet, because he needs to either accept my rent payment or demand rent. So if I Venmo'd him my monthly rent payment, then could I sue him? Yes, I could sue him for the rent I paid to him for the uninhabitable apartment, the money I paid to file the lawsuit and serve it on him, any money I paid to an attorney to help me file my lawsuit, and since I met all of the requirements, I could ask for special damages, such as if I stayed at a hotel because I didn't have electricity, or maybe the cost of an external battery for a medical device like a sleep apnea machine, or even if I had to buy ice for an ice chest to keep food cold because my refrigerator didn't work because I had no electricity. Those are all things I could have sued for. So this is nearing the end of the presentation, and I hope I provided you with information that will help you if you're ever in such a situation. Landlord-tenant law is complex, and I know the hour we have here today isn't enough time to cover every aspect of it. So I'm providing you with a list of resources that you can check out. We covered a lot of information today, and there is a lot more. I know everyone's situation is unique. So if you're facing a possible breach of the implied warranty of habitability, I encourage you to read Civil Code 1941. It's available on the internet. You can go to the San Diego Law Library. They can help you find it. Read your city's health and safety codes, and talk with one of the advocates at the many organizations such as San Diego Volunteer Lawyer Program, Legal Aid Society of San Diego, Tenants Together, Housing Help SD. They're also great resources to read the California Department of Real Estate's website. So I think we have time for this, but I think we have time for questions. Anyone has them? Oh, we have a lot of time. Put them in the Q&A.
Looks like we have one. Let me see what it is here. So this question is from Jenna, and she's asking, can you provide some information about the landlord's responsibility to pay for temporary housing while significant repairs are being made? Does the landlord pay, or does the tenant pay and get reimbursed?
So most leases will have a provision saying if the tenant has to move out because of repairs, that the landlord will pay. There is also a wonderful thing called renter's insurance. It's about $9 to $15 a month. And if a tenant has a situation, let's say the roof has leaked and they can't live in their apartment, mold and mildew is building up, renter's insurance will usually pay to house the tenant in a hotel for a few days while the repair is being made, and then the renter's insurance company can sue the landlord to get those costs back. So there's a lot of different options. So you want to always look to your lease. If you have renter's insurance, look to your policy, and always talk with your landlord. Like, it's, you know, I have to leave my home because you're making repairs. You should be paying, the landlord should be paying for that. Yeah, good question, Jenna. Thank
Yeah,
you.
and Stephanie, Jenna was asking for some clarification on this same subject. She was asking, is there any state or local statute, you know, that covers this, or is it just about the lease?
Let me pull up my notes. I have this going on with the client right now. If the repair is dictated by the code enforcement, I believe there is. Like I said, every situation, I want to go look at my codes. I don't want to give you any wrong information. But look to your lease first. There should be a provision in there that they have to provide you with a reasonable accommodation. So I have, you know, one lady, you know, she has a 4-bedroom house. She has like 5 kids. And the landlord said, okay, well, I'll give you the rent for the time you're out. And she's like, well, I can't find anything comparable to what I'm renting at this price that you're giving me on such short notice. So that's a time where the landlord would have to step up and help her get something that's, you know, it doesn't have to be exactly the same as what you're renting, you know, that 4-bedroom house, but in that exact neighborhood. But, you know, you gotta, like I said, it's this partnership. You gotta work with each other, and sometimes you gotta not get exactly what you want because it just might not exist out there. Yeah, I'm sorry, that's not the best answer, Jenna. Let me, if I could access my laptop, I could pull up a code maybe for you. Okay.
And, you know, I'll make a plug for the library for anyone wanting information about, you know, specific statutes, codes. You know, we're looking for legal information. You can always contact us. You can call us or email our reference desk, 619-531-3900, or refdesk, REFDESK, at SDLawlibrary.org. And we'll do our best to try to help you find that information, maybe even save you a trip into the library if it's something really simple, like you're just looking for a copy of a specific code section. So another attendee has a couple of questions. His name is David, and he is living or was living in a condo with a condo association and had a landlord that was refusing to take care of a health and safety issue, and even contacted the city and they refused to get involved. And so do you have any wisdom or comments on that situation? And does being in a condo with an association affect this subject at all?
So that shouldn't affect whether code enforcement comes out or not. What I might be able to guess is maybe they didn't understand the severity of the situation, or maybe it wasn't a situation that was substantial. So maybe that's why they didn't come out. You know, if I sent them a request that said, I saw a spider in my bathroom, you know, they're not gonna come out. But if, you know, I said there are significant rat droppings and I see rats every day, you know, that would be more likely to get them to come out. So it might just be what you said. But yeah, that's usually they follow up.
So we've still got time for more questions if anyone has any. Okay, here's another one. Regarding the temporary relocation costs, and this is from an anonymous attendee, most leases I've seen limit the landlord's obligation to a pro rata reduction in rent that's due.
That's true. Yep.
Yeah. Okay.
But again, I have a I have something written on this. I just can't access it right now. But the landlord does have a requirement to provide you reasonable accommodations if they are even temporarily removing you from the property. But again, it's you know, it might not be the exact same thing you're renting in the exact same location, just because that might not exist. So, you know, if the I would say if the landlord isn't being reasonable, you know, push back a little bit. But yeah, they can't just push you out into the street kind of thing. But yeah, I again, specific situations, and it's a little bit off topic, but it's a good question. Yeah.
Here's another one from Rosanna. She's asking, could an arbitration clause in a lease prohibit the tenant from going to court?
So not small claims court. So if you have a claim for $10,000 or less, you should still be able to bring that claim in small claims court. Another great option we have here in San Diego is the court provides free mediation. So you don't even have to file a lawsuit. You call their free mediation line, you tell them your situation, you give them the other party's contact information, and the mediation group will contact the other party and ask them if they want to mediate. So, you know, try to work out your differences and come to an agreement before a court case is even filed. And it's completely free for San Diego County residents. It's an absolutely fabulous first step, because, you know, it might be the last step. And, you know, a problem when you do go to court is the judge gets to decide. And, you know, you kind of are giving out control of the situation, but in mediation, you still have some control. So I just want to plug that program. I think it's terrific.
Yeah, so is that, I assume that mediation program is something someone could find on the San Diego Superior Court website if they looked there. If you just Google San Diego Superior Court, they have a great website. It has a lot of resources on it, but you should be able to find information about the mediation program there. And again, if you look and you're having trouble finding that, you can give us a call or email us at the library and we can help you find that information. So let's see, here's another question. If part of a residence is legally uninhabitable, say one bedroom in a multi-bedroom house, does the one tenant who is most effective have different rights than the other tenants? That's a good question. What do you have to say about that one?
Oh. All right, so you
You've
have
got
a roommate
multiple tenants in
situation.
a multi-bedroom house, but one bedroom is most affected.
So I'm just gonna assume, well, does everyone have a different lease? Are we in a situation where all the roommates are on the same lease? Or is it a like a lodger situation where each roommate has their own separate lease? That's what I would ask first. Because if you're all on the same lease, you are all jointly responsible together. So things that happen to one of you happen to all of you.
So our attendee did respond, Stephanie.
Okay.
She says same lease, joint and several.
Okay, so then it's an issue for everyone on the lease. Maybe if you do the withholding of rent remedy, so let's say, you know, only your bedroom is affected, you work out with your fellow roommates like, hey, this is really only affecting me, so you guys aren't going to share in the rent reduction. I'm just going to be the one to reduce the rent. Something like that. That's a good question. Yeah.
So many variations on these landlord tenant situations.
We should have a roommate presentation because
yeah,
so many roommate situations in San Diego too. Yeah.
I'm still waiting for someone to ask you, how do you find $1,000 rental in San Diego?
Oh my God.
I don't know how long ago that was, Stephanie, but I was shocked when you said that.
This was like 2016.
Not that long ago.
Yeah, it was so small. Like I said, it was only 240 square feet. It was like a little casita off a little main house. But yeah, so, you know, you price, space, but yeah, I was not leaving that place for as long as I could.
So we have an attendee, Stephanie, asking which, you've listed a number of agencies here that potentially help with landlord tenant issues. Which is the best organization to contact to follow up in a situation regarding health related issues not resolved by the landlord? So, you know, Stephanie probably, because she's affiliated with San Diego Volunteer Lawyer Program, may not be objective, but what's your answer to that question?
So I'll tell you, the California Department of Real Estate, that I listed because they have a lot of publications you can read. Legal Aid Society of San Diego, you have to meet an income requirement. I'm not so sure about the other requirements for Tenants Together and Housing Help SD, but I do very much like San Diego Volunteer Lawyer Program. So it's also who has time to help, because a lot of people are trying to access these resources. So you might want to reach out to multiple ones and whoever can help you first.
Yeah, I think that's good advice. And right now, unfortunately, I know both Legal Aid and San Diego Volunteer Lawyers Program is getting a lot of calls regarding landlord tenant issues of all types, including evictions. So they're busy, you know, for someone really trying to get help, it may be best to contact multiple service providers. And that way, you know, try to figure out, you know, who can help or who might be available at a given
Remember
time.
That free mediation by the San Diego.
Yeah, free mediation. Yeah, that actually sounds like a great resource, and I'm glad you mentioned it. So we have an attendee asking, what is the best way to get a code enforcement inspection? And if it's in the city of San Diego, is contacting the city the best way to do that?
There is actually on the city's website, you can make a complaint to code enforcement. And I find that to be just the simplest way.
Yeah, I think if you go on sandiego.gov, it's just San Diego, like it's one word.gov, and search for code enforcement or code compliance, you should be able to find, you know, where to make a complaint online.
Yeah.
Or phone number to contact that agency at.
And it's nice because it also gives you a little, I don't want to, kind of like a receipt that you made the complaint. Because like I said, if you have these issues, you know, keep good documents, keep copies of everything you submit to the landlord, to the city, take photos, videos, just in case the problem isn't resolved and you have to take other action, you have that documentation.
So we still have a few minutes, no questions pending. If anyone else is thinking of any, don't be shy. Take advantage of Stephanie being here today.
I will do my very best to answer the questions. I know I can't answer all of them, maybe, but I'll absolutely try my best. I focus on housing because it's something that affects all of us. And I know some terrific landlords. I know some terrific tenants. And, like I said in the beginning, you really want to develop a good relationship with your landlord and with your tenants because it's a partnership. Repairs happen. And some of them can't be fixed immediately. Maybe there's not a repair person that can come out. They're also very busy lately. So it's all about having reasonable expectations and knowing that you're both there working to solve the problem and you're not just trying to blame each other because something happened. Yeah.
I think that's good advice. Really try to work things out, but maybe at the same time, make sure you document things, put things in writing, as you mentioned earlier, take photographs, keep documentation of what is going on. So if unfortunately you do end up having to do repair and deduct or go to court or something like that, you have your documentation and you can back that up.
Yeah.
Okay, well, I think we're out of questions. So thank you so much for being here, Stephanie. I appreciate everybody attending to and asking such great questions. And please reach out to these agencies that are listed here. Maybe take a snapshot with your phone real quick before we wrap up if you want to do that. Or you can always contact again the San Diego Law Library. We can, if you forget the names of these agencies or need their contact information, we can help you with that too. So thanks, everybody.
Thank you for coming, everyone. Have a great rest of your day.